All right, good afternoon. It's May 28th. We're back at Senate Judiciary doing hopefully our last meeting for the conference committee for S12. We have some new language that we agreed to yesterday, and we have Ledge Counsel with us just to give us an overview one more time and make sure we're all good with it or not. And then hopefully we're also with it, and then go from there.
Yes, thank you, Eric Fitzpatrick with the Office of Legislative Counsel here at the Senate Judiciary Committee Chair said to do a quick walkthrough of some of the proposed new language in the Conference Committee report for S12. As I'm sure Conference Committee members recall, the general rule is that sealed criminal history records are not able to be used, but there's a long list of exceptions under which these records may be used, and they begin on page 25 and 26 really is where this long list of exceptions, where records that are sealed may nevertheless be used by certain listed entities or for certain listed purposes. So the proposal here, you may recall in the
I'm sorry, Eric, what copy do you have here? 25 and 26. Draft number 1.1.
Yep. Should be kind of highlighted. I think I see that your version is gray, but
Yep.
The new language starts in 26 that should be highlighted. Is yours highlighted on your head?
Yep.
Okay, great. So yeah, so the proposal here is that with respect to certain not actually uses but disclosures. So again, the concept is that the listed agencies and entities can continue to use the sealed records provided they're in this list of exempted parties. The question is, there's going to be some added process required if they intend to disclose it to another person. So, for example, you could use it, you could review it, you can make decisions about if you're a criminal justice agency, for example, to whether it might be relevant to investigation, that sort of thing. But before you disclose it to someone else, i.e. in a deposition or to an expert witness who you might want to look at the record before examining the case, there is a second layer of process that has to be gone through, and that is at least with respect to criminal justice agencies, that goes over on the bottom of 26, top of page 27. And this sort of tracks the language that was in the Senate version. Remember, the Senate version had required this process for criminal justice agencies, but for them to even access the record. So this preserves the court process, but for a narrower set of circumstances. It's only if they intend to disclose it to other people. Well, they can still use it as they can under current law. But before they disclose it to somebody else, they have to go to court and have the court make a finding that disclosure is for criminal justice purposes.
And then just to clarify, Eric, maybe you were just about to get to it, but if the record is to be used in litigation, there's a process there too.
Exactly. Oh, you're exactly right. I was going to just mention that initial process of finding that it's for criminal justice purposes, disclosure, I mean, can be done ex parte, but it doesn't have to be. And then if they, as you were saying, Senator Hashim, want to go on and use it in court, then there's that additional process that's over on bottom of page 25, over on top of page 26. And that's where the court's going to have to look at, is it relevant? Is it not prejudicial? That sort of thing. The court has to make that finding if they want to use it in court. They don't.
No, that's 26.
Bottom of page 25, top of page 26. Exactly. Yeah. Okay. That's if they're seeking to use it in a court proceeding. Last point to make about disclosure, in addition to this extra court process with respect to criminal justice agencies, other folks you see in subdivisions 1 and 3, pages 26 and 27, this would apply both to anybody seeking to use the sealed record in litigation, including criminal defendants. They don't have to have this court finding for disclosure, but if they do disclose it, they have to provide notice to the person who's receiving it that they have to essentially not disclose it to anybody else. That is actual. There's a fine that's associated with disclosing it beyond these parties who have access to it. You can't give it to other people who don't have access, unless you already do, you're subject to the fine. So that's the gist of that process. And continuing on this point of unauthorized disclosure, over on page 35, it's another change. This is what I just mentioned, the civil penalty for unauthorized disclosure. See, the way it's phrased now, under current law, it's only a state or municipal employee, contractor, et cetera, who unlawfully discloses these sealed records. But now you're providing this long list of exemptions, right? These people who can use these sealed records. So it makes sense to just say anybody who discloses it when they're not supposed to would be subject to this fine. So it just changes the language to a person who knowingly accesses or discloses sealed records.
And remind me, what is this long list of exceptions of people who can use these sealed records?
Yep. It starts on page 26 and goes over to bottom page 29. So there's 12 different entities and circumstances under which sealed records can be used. So ranging from, VCIC, state's attorneys, a person whose own records have been sealed, persons conducting research, DCF employees conducting investigations, adult protective services, that sort of thing. Those are just, but each of them is an identified instance in which both the Senate and House have come up with particular parties who should have access under certain circumstances. But the language that you were just looking at says that's fine, you can use it, but you can't give it to anybody else. If you do, then you're subject to this. Lastly, it's just struck language. You see the language from page 36 to 30, actually no further, 39. That's all struck. That had to do with deferred sentences. You remember the Senate version, because under current law, deferred sentences are expunged, not sealed. And the Senate kept that process for deferred sentences in particular, where the House proposal was to change those to sealed also, at least under certain circumstances. So the proposal here is to adopt the Senate approach, which is to keep keep for deferred sentences, the record to be expunged rather than sealed. So strike that language that's in the House version. That's the PD. And lastly, there is the addition of the statewide model policy on use of sealed criminal history record by law enforcement agencies. You see, that's totally new. The both versions starts on the bottom page 42, goes over on 4. Use of the existing definitions of criminal history record purposes and law enforcement agencies. And basically says that this is tracked on, there are other places in the law where you have statewide model policy. They have for bias policing, they have them for blanking on the phrase. I always say tasers, body cameras, and automated device for tasers. It's a more technical phrase.
Oh, CEWs.
But
CEW.
controlled electronic something. Weapon. There we go. Anyway, there's a number of other examples that require statewide policy. This one happens to be based on the format that you had for the CEW controlled electronic weapon statute that's already in law. This goes into that list as well as the proposal. It just basically requires law enforcement agencies to establish, in the bottom of page 42. Statewide model policy governing the access and use of sealed criminal history records. Criminal Justice Council establishes it. And then law enforcement agencies have to adopt it. And they're given a timeline. So the council has to establish it by December 15th of this year. That's found on page 42. And then there's 3 months given for law enforcement agencies to adopt it. That's over onto page 43. So if they are covered by this, they have to adopt the policy that's established by the Criminal Justice Council. And if they don't, then they shall be, if they go about their own efforts, they're deemed to have adopted the one that was established by the Criminal Justice Council. Again, that's the same way it's done for several other issues under current laws. And this policy, what it's going to be in it, well, then you see that's on page 43, defining the types of sealed criminal history records that may be accessed and used. Define this is number 2 now, moving on. Define a record keeping system through which the law enforcement agency maintains records of each instance in which an officer has accessed or used a sealed criminal history record, and lastly, comply with applicable state and federal law. Criminal Justice Council is charged with adopting rules to ensure that the policies and standards of the section are met. And lastly, page 44, Criminal Justice Council also develops, publishes, and periodically reviews the statewide model policy. Great. You bet.
Yeah. There was a question I have. So current law, the usage of sealed records. So right now, there is no statewide policy for the use and access of sealed records, but presumably every department has their own standards of how they may or may not use sealed records. Does that sound about right?
Yeah, presumably so.
And if an entity wanted to use sealed records in court right now, let's say this bill doesn't exist, they wanted to use sealed records in court right now, remind me of a process, if there is any.
I think it's developed by the court, and I don't know it off the top of my head.
Okay.
But I think it's judicially governed because it's not in the statute.
Okay, so it's kind of a piecemeal, like a patchwork.
Yeah, and there are places, for example, I think there are some particular instances in statute where there are criteria listed for whether or not records may be used, but it's not a general policy. So there may be particular cases. I'm thinking of possibly, for example, limited. I think it's in juvenile records that there's limited exemptions for the use of juvenile records. I remember that list. There's a couple of particular that are identified in statute.
And it's a list of the individuals that can.
That's right.
Yes. Okay. So, I mean, in my opinion, I think I'm supportive of these changes. I'm really appreciative of the statewide policy. And I think that the judicial review component of this creates a statewide system as well, or a statewide standard for how the process goes. And also just operationally makes more sense. And we're getting rid of the changes of the deferred sentence, which I'm a fan of. So, I'm in support of these changes. I don't know if anybody else wants to chime in or share any thoughts.
I didn't like the policy, didn't want the policy, but definitely very good with it. I think it actually can be helpful. I'm slowly convinced that it's good to put it. So,
Well, I appreciate this. Anybody else? Everybody
have the discussion.
Yeah.
Yeah.
Well, good.
Yeah.
All right, so excellent. So, Tom, you good?
Yeah, I'm good.
All right, so I know this has to be edited and you will go around and get the signatures.
Exactly.
And you'll have to figure out how to get Tom's signature if he's not here, how we can do that.
You don't have it. You can go with 5.
Or can we do it by permission or no?
I don't know.
If you.
Derek, will that be ready today to sign or tomorrow?
I asked the proofers to have it by 4:30, so it's with the editors right now.
Okay.
But it's okay. It's fine to go up to you guys. You have a couple more days. So
Yeah.
if you'd rather wait,
Can you just do an e-signature? Just put the S and the dash and then.
possibly.
I mean, I'll go on the record, giving whoever permission to sign for me. I mean, I got no problem with that if that's a legal way of doing it.
Yeah,
I'd be all right.
if you can just look into it.
Yeah, I'll check it out.
So this is our, we have been given the permission. If that's okay, I can sign for Tom.
Okay,
as well.
great. And the bill is in the Senate, am I right? Is it right now?
yes.
Where's it right now?
I think it's here in the Senate.
So I was wondering, who does it go to first? But I'll check with that too.
I think if it's a Senate bill, we go first.
That's what I thought.
Oh, you reported first and then I reported?
Yeah.
Order. Yeah, because it all ends in the house, or in the body that originated it, right?
Well,
Right.
Senate is the body that originated.
Right.
So this is, it doesn't matter if that bill is actually here because it's, it's a committee fund, but you're part of that.
All right. So I'm fine with, so you would report it.
I'll find out what we can, I mean, if it's edited in time and if we clear this up and get the signatures, we're meeting to get it 4:30 and I might try to convince our people to let me go ahead and take it off pending notice calendars. Just to move it along.
Okay.
So,
Then I can report it tomorrow.
so we can get out here on Friday night.
Yeah, that would be great.
That'd be fantastic. Doesn't help, man.
Fantastic.